Welcome to Clause 8, the #1 podcast on intellectual property, trusted by top in-house counsel, judges, and policymakers worldwide. Hosted by Eli Mazour, we bring you in-depth conversations with the personality shaping IP. Brought to you by TradeSpace, where ideas take flight.
Many of you know that I joined a new firm about a year ago, and I actually joined a nice team who, since I joined, and before that, a long time before that, we've been just talking a lot of stuff about pen prosecution, pen drafting, what's happening with the pen practice. And, I do this podcast, and I'm like, all right, we got to have you on so we could kind of talk about the stuff we talk about and share with the world what kind of we do and how we think about things. So thanks for doing this.
Yeah, absolutely. Happy to do it.
So, me and you kind of started practicing, we both do pen prosecution at an interesting time, right after Alice, pen eligibility became a concern, and it probably kind of informed the way we think about our practice, because I imagine that if you were drafting applications outside of business methods, let's say, you just, you get the inventor's disclosure, you describe what they say in the legal terms, find out what the prior art is or whatever. But for the stuff we worked on, that wasn't quite sufficient. And do you remember that? Do you remember kind of becoming aware of that and kind of becoming aware of Section 101 being an issue and kind of having to navigate that?
Yeah. It was a time where most people that you kind of talked to had no idea what to do. And I think you and I both had to experiment with a bunch of different things to actually find out what would work.
And I guess, what do you remember, like, seeing what wasn't working? Like, what was your inkling of something the regular approach wasn't working?
I think what everybody else was saying at the time was that, we just had to wait until the laws changed, and things that they were doing, they were literally just putting physical in front of processor. I don't think most people weren't coming up with a lot of creative ideas. They weren't really trying a number of different things. And actually that's, I think I told you before, right? This is basically how we met, why I reached out to you, because you were the first person to actually write an article with actual practical advice about how to navigate 101.
And, I do remember that time, because I think it was like, first Bilski came out, right? And which gave some false comfort to a lot of patent attorneys that all they had to do is put in buy a computer and that would be sufficient. And then Alice kind of came out and they crashing. But it's funny you say that they just have to wait it out, because I do remember I was at my first firm back then. Some advice was like, oh, you just file an appeal, and then by the time the appeal is done, the problem will be fixed, and then you can address it with whatever the trick is. And people were looking for that one quick trick, like, put some stuff, people were like, you say physical processor, but some like throwing a computer into a patent application and not tied to whatever. And, that stuff wasn't working, and you had to kind of find new ways. And I guess the problem with that, obviously, is that if you're trying to capture inventions that have to do with improving something that's an improvement in the business world, what do you do? And I guess, I don't know, maybe kind of tell your thinking about it maybe now, or back then. How did you think about, like, how do I get to a point where we can actually get a patent starting out with like a business invention?
Yeah, so initially I was always focusing on like what the law was, what the law said, all these case decisions that came down. And there was one in particular, it was called, it was called Core Wireless. And I think the turning point for me was when I attended this oral hearing and I argued in front of these judges about why our case was similar to Core Wireless. And their response was that Core Wireless was about, an improvement for small displays. Even though the claims said nothing about small displays, and the court decision itself, was based on, other aspects, I realized that, like, it's really important to have story integrated into our applications, right? Story about the technical improvement, why it provides that benefit. And that's how I came up with our approach that I like to call, like, an impression approach.
And, there's it's interesting you say that. Obviously, there were a lot of court decisions, and the problem with the court decisions is that they came out both ways. But there were nuggets in them about like what could actually survive in this new world, and some of those nuggets had to do with technical improvements. And then people would just write a patent application, and then they would stick at the end of
Right.
their application
Right.
technical improvement,
Right.
and then they met the realities of what happened at. So you draft obviously an application that you want to withstand if it ever gets challenged as a patent, but also you're trying to get a patent office. But even at the patent office, examiners are like, come on, you just you have a whole application about what this is really about, and then you put some improvement that's completely unrelated to it at the end, and they're like, we're not gonna grant you're not gonna overcome section 101 rejection based on that. It's not gonna be patent eligible. And I think you kind of you formulated I think you have a you formulated kind of the kind of things that you were both talking about. It's really about telling a compelling technical story, not just in one little end of the paragraph, but throughout the application as you lay out.
Right.
So before you start drafting that application, you have to get a step back and saying, all right, this is the invention, but what is really the technical improvement? And you might need to get that from inventors, and you might need to figure that out. That is a challenge now that I think about it. Like you have inventors, obviously, who are day to day. Their task might be to improve things from a business perspective, not to improve technology, but then you need to find out like what is the technical improvement. How do you do it, or how do you kind of think about figuring that out as you're talking to the inventors? Or
I think what we typically do is we just kind of take this step back. We understand that the inventors are focused on their specific use case. So if it's, if they're with a financial or a fintech company, they're always talking about money, credits, debits, transactions, and not really focusing on, what's the underlying technology that makes all these things possible, right? And so what we do is we take a step back, we focus on why their particular invention works the way that it does and what helps it work. And then formulating a strategy that focuses on the underlying technology and why it provides whatever the technical benefit is.
Obviously, a challenge with that is kind of setting the inventor's expectations, right? About trying to explain what we're doing with their invention. Any advice about that? About like communicating? How do you think about that? About communicating with the inventors?
I'm fairly straightforward with it. I let them know that if they present their financial use case first, that they're going to get rejected, because that's the first impression, right? If it deals with a financial use case, it's probably not patentable, and that's the impression that a lot of patent examiners have. And so the idea is that you present the technology first, and then you present the financial use case afterwards, right? And so that the first impression is already set, that it's about the technology.
Yeah, and I think you kind of articulate as a first impression, and I think it's true in life. Sometimes you look at it, but I think what you were talking about, correct me if I'm wrong, is when somebody picks up the patent application or patent, what is going to be their first impression,
right?
And we do. I guess what are can you talk about like what are the things that you do to kind of as you're thinking about how to set that impression?
Yeah, the traditional thing to do is you write claim one. Claim one is usually your broadest claim, and then you go narrow from that. But there's not really a requirement to make claim one your broadest patent, right? And we're not saying that claim one should be narrow, but I think that claim one should have context so that it's related to the story that we're telling.
Yeah.
And so the very first page, some people like backgrounds. If I'm going to have a background, it can be very, very short. I'd like to tell the story, if I can, all in one page on the very first page. And then on the very first claim, I like to kind of link that back to the story with the context that whoever the reader might be, it doesn't have to be the patent office, it could be a judge in the future, a jury, whatever that might be, can easily realize that like this relates to the story and why it provides the technical benefit.
Yeah, obviously like the title, and I think important part of like telling that story is starting, if you're going to describe the problem that they were solving, the problem better be technical, right?
Yeah, it better be technical. Yes.
You don't want to start problem. We weren't making enough money, and then we figured out if we charged another dollar, because then the first impression will be, no, you were actually solving a non-technical problem, and now you've come up with some kind of rationale about or technical, and then weaving that through. It goes to be, there's obviously some stages. It's like the denial, and then after Alice came out, denial, and then acceptance. And one thing that I think people realize eventually is that it matters a lot who examines the application of the patent office
Yeah.
or art unit. So there's all these tools now, like the patent boss, art unit predictor, and a bunch of tools to predict where it's going to land in the U.S. Patent Office. But the way a lot of even these tools are designed is people draft a patent application, and then they wordsmith to kind of land in a different art unit. And what's wrong with that? Why? What it's like the...
I think all you're doing is tricking the predictor, right? And you don't necessarily know where it's going to be, where it's going to land at the patent office. And even if you end up being granted a patent, whether that patent is valid or not, I mean, that's going to be decided by somebody else other than the particular art unit examiner.
Yeah, that's a good point. We've actually seen, and I've obviously written about it, that some art units, as we saw, that in the beginning, like if you put AI to your claims, then
Right.
it was an AI art unit. Those are good things, but then they train those examiners on 101, and then there's a lot of 101 rejections there. So that's an issue if you're going to be kind of filing an application today and then getting it examined maybe a year from now. The art unit that even if you end up in the art unit that you want to end up in, it won't. You might end up with a one rejection, and then, like you said, if you get the patent application allowed and you're issued patent, at that point, whoever's on the other side is going to have endless resources,
Right.
to kind of figure out what you were wordsmithing there. If you do get a one-on-one rejection, you want to have that story actually in your application, where you're able to kind of overcome that. And wordsmithing alone is not going to let you do that, even if even if you have like a half-baked first impression that it's technical.
Right.
So if you do it off, so that's kind of let's I want to kind of take a kind of maybe a more detailed look at the approach. Let's say you figure out, hey, this was kind of a technical implementation before, and that was the technical problem that existed. This is the technical solution. As you draft the application, how do you work that in? You said you put it on the front page, but as you're describing different aspects of the application, what is your kind of... do you have any kind of thoughts about working that in a way that's...
Yeah. No, I mean, we integrate all aspects of it throughout the application. It's definitely going to be on the first page. It'll be at the beginning of the detailed description. The features tied to those benefits are recited in the claims. And as we discuss those claims, we'll also discuss why certain aspects of the application or certain aspects of the claims have or provides those benefits.
Yeah. And I think it's an important point. Like, ideally, you want the crux of your invention and the technical improvement to kind of coincide, and that whatever amendments you might have to make to help with one, to overcome, let's say, prior art, will also help you kind of, if you do have one-on-one rejection,
Right.
to help with that.
Right.
And it is difficult. I guess, what is it like? You've obviously, you have a team of patent agents who I'm guessing weren't and attorneys who weren't exposed to that approach before they started working with you. Like, what is it like training somebody? Any kind of how do you do that? To learn to do that, I guess that's what I'm trying to figure out. Really asking you, like, how do you learn to do that?
I used to think that it was a science.
Yeah.
I used to think that you could literally just tell somebody what the rules, the guidelines are, how to do something like this, and that they could eventually learn to do it on their own. We even did a presentation for one of our clients where we presented to, like, I don't know, 13 or 14 other law firms about what our approach was, how to do it. We gave them a bunch of different examples. And, from what I saw and what I heard, quite frankly, like I think maybe one or two, maybe even a few attorneys, but like really nobody learned to do it the way that we've done it. And for us, quite honestly, it's an evolving approach, and we're always adding new techniques to it. But I think it's something that I think it's an art. I think that you have to practice it. You have to get trained on it, mentored. There's a lot of back and forths, but you just need the reps.
Yeah, I guess, somebody's listening to this and, well, I guess, why do you think it's so difficult? And somebody listening to this and they're like, I want to kind of do that. What do you think is a good point to start, or something like any advice about kind of trying this approach? Let's say you were training somebody new. What would you tell them, I guess?
Quite honestly, I think part of the reason why it's so hard is because it's a lot of the aspects, even though like the concepts seem very easy, a lot of the concepts themselves are contrary to what people traditionally do. For example, claim one, writing the broadest claim, making sure that you're not putting in any language that people might think might narrow it. But I mean, these things aren't what typical patent attorneys do, right? And so even if you're teaching somebody this, you might have other partners that train them to do it the traditional way. And so there's these two competing approaches. I just tell them, and I tell them that it's hard, that it's something that they need to practice with, that they need to focus on, because I think by intentionally focusing on this particular approach, that's pretty much the only way that you can learn it, like through practice, deliberate practice.
Obviously, I do a presentation on this topic that you've helped me come up with, and when I talk to kind of new attorneys, and I go through presentation, they're like, "Oh yeah, this makes a lot of sense." I'm like, "Do you have any questions?" No. And I think the difficulty comes up is when they actually get a disclosure,
Right?
And then they're like, "Oh no, this approach can't work. This is going to be an application where we're just going to have to risk a one-on-one rejection,
Right. Yeah.
and this approach is not going to work for that." And kind of they're like, "No, this not going to work," and it does, and it's kind of almost magic once you start using it. In that you could find out the technical story and find out for things that I guess if you haven't done it before, like you said, it would seem like I don't want to say unnatural, I guess, to some people to bridge that gap as they're doing it and finding that out. So I think that's a kind of a interesting point, but yeah.
Yeah, no, you're absolutely right. That is what I hear all the time. That I see how it works for this example.
Yeah.
But then they're like, "Oh, but it's really difficult to do it here. I don't think that you can do it here."
Yeah.
And then they just stop, right? And I think that's the problem, is that when they hit that barrier, they don't dive any deeper.
Yeah.
And I think that's what you have to do.
Yeah. And I think we're lucky now, I guess, now to playing this, but because everything these days, probably there's kind of a technological implementation of it before.
Right.
So it's not really automating something that was done manually, likely, which I think was the case maybe when Alice first came out, that they were actually automating some manual processes or whatever. So that's the case. The other piece I guess I want to talk with you is, prosecution. I think you have something we both kind of join about is like we're both huge fans of examiner interviews.
Right.
And I remember when I started practicing, and I might have told the story before, is that I had a partner who was training me, and I was looking through our document management system, and I saw other attorneys were doing interviews, and they were reaching agreement, and they were kind of relying on that agreement to move cases forward towards allowance. So I brought it up to that partner who was training me, and the partner goes, "No. We're going to present our arguments. In response, we're going to send it to the patent office. They're going to send us another office action, and then we'll take it from there." And I think from his, because of when he started practicing, he didn't think examiner interviews were effective.
Right.
And it took that just like back and forth. I guess what made you think examiner interviews work? Kind of what brought you around that?
I actually interviewed pretty much every single case. For me, it was helpful, like in terms of getting my story out there, explaining to the examiner how things worked. And then, quite frankly, like you have all the data that's out there right now that indicates that examiner interviews, that they help, right? They help for allowance. But at the same time, I think what I understood prosecution to be is that you're really working with another person, right? You're just not, it's not a robot on the other side, although sometimes it might seem that way. You really, this whole job that we have that I thought was about law is really about people. And that's why I think examiner interviews can be very helpful. They're not always helpful, but I think they can be very helpful if you can utilize all the tools properly.
When you think about an interview, like what's your goal? Like I know you have some.
I guess there's two primary goals, and to the extent that I even get one of them, I'm happy, right? And the first goal is always to understand how the examiner is approaching or is interpreting our invention or our claims, as well as the references, right? I think that's always useful because even if they end up disagreeing with me, and the second goal being, obviously, I want them to agree with me, but even if they end up disagreeing with me, at least I can take back knowing what they believe in, what they know about our claims and the references, and then I use that to basically tweak our response.
Yeah. It's crazy how many times, me and you are a huge fan of examiner analytics. So we know examiner analytics. We look at the office action. We look at the prior art, and you form some kind of like, let's say the first impression of what the examiner is thinking, and then you get on the phone, and the examiner tells you something completely different. Where it might be super helpful sometimes. They're like, oh, if you just do this, and you would have no way of knowing unless you got on the phone. And there's, for whatever reason, that happens because there's some dynamics at the patent office where the supervisor might tell them, like, the only way you can allow this case if X happens, but they don't want to put it in the office section or whatever it is. And you won't find out until you get a call. So just to get, even if your whole interview is just getting on the phone and like you're going saying, all right, what's on your mind about this application? Even that would be worthwhile. But part of a goal is the first goal, right? Trying to convince them our way. And I guess, how do you think about that? How do you convince an examiner? Because obviously by the point we get on the call with an examiner to do the interview, the examiner has already spent time, especially now that there's no first action file program, he has spent time, examining this application, drafting the office action, putting his arguments, together. He's already made his first impression. How do you get them to an agreement once they've already kind of invested themselves into that?
There's a book with a lot of concepts on this. I think I've probably mentioned to you many times, right? It's called Never Split the Difference. It's a book about, it's not, a lot of the stories about are about FBI hostage negotiation scenarios, but a lot of it works here, even in examiner interviews, because I think what the examiner often wants is to also feel like they were understood, right? They want to get their piece across. They want to feel like you listened, that you understood. And then once that happens is where the magic starts to happen, right? Where you acknowledge, certain things, you let them know that you realize that certain aspects of your claims may not be inventive, but then you can go on at that point to explain what the inventive feature is, right? Why it is novel over the art, why it provides that technical improvement, right? But I think you have to get to a point where they're not defensive, where by getting them to feel like they're understood, that you've listened to them, that you understood, that's when they start to open up, right? And I don't know, that's been so helpful for me.
Yeah, and this connects to your point is that, actually what I'm kind of training a new attorney or something who hasn't done an interview before, one piece of advice I give them is like, if an examiner's talking, just let them talk, because they might drop a nugget. Even if they're disagreeing with you, they might drop a nugget that you can connect back to and say, oh, if you say that, well, maybe we do have something in our specification or application to support that and come up with an idea that fits that. So that's, I never thought about exactly that way, but yeah, listening to them is such making sure they're heard.
Yeah.
Is such an important part of that. The other difficult part that I find is, because I guess I'm and maybe we're maybe degree differences. I think maybe we're slightly different, but I think it's very important to do everything you can to reach an agreement.
Yeah.
But some who aren't used to interviewing, they often hear an examiner says, "We disagree," and says, "All right." Examiners often say this. They say, "All right, you laid out my section. It's agree. We agree, disagree. Just go ahead and file a response."
Yeah.
What's your thinking? Like, how do you get over that? Once you're at a point of disagreement with an examiner, how do you push forward through that? I guess what's your.
To be honest, nowadays, I don't even ask whether there's an agreement. I don't think I even put in the response that we ever reached an agreement or that no agreements was reached. I just kind of indicate what was discussed, what my points are in the response. But quite honestly, like you said, right? A lot of times they're talking and they'll drop these nuggets. And, if I hear certain things that they say, and I know I can link it back to the specification, I'll actually say, hey, why don't we look at paragraph, whatever that might be, and say, hey, what do you think of this, right? And see how might we integrate this into the application so that, for example, it overcomes 101.
Yeah.
And so to the extent that you can get the examiner to come up with those amendments themselves and have them kind of give those to you, it's actually way easier because they came up with it, right? And then they're less likely to retract or change their mind about it because they're the ones that came up with it.
Yeah. And, this is also an art, and I think maybe it's like the difference in approach. But, my concern is always, all right, I'm doing this interview, I'm getting somewhere with the examiner. Are they going to remember what we discussed when they pick up the response?
Yeah.
And I always think about and I don't know what the right answer is that at least if I get them to agree to something, that will at least correct. But I think what you do is, at least as you can document whatever they said in terms of even maybe sometimes being specific. And, I approach the interview summary, the examiner suggested blah, 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 or whatever, as long as and they could look back at it and say, yeah, that makes a lot of sense. It kind of gives me a clear mind. And actually that brings me to another point that maybe it's part of what you said. The third part of doing the interviews is leaving space open for the examiner to want to reach agreement with you.
Yeah.
Even if you didn't do it during that interview, to kind of work with you after you file that response for whatever it is. And how do you think about that and how do you kind of make that happen?
Throughout the interview, I'm always trying to get the examiner to provide their suggestions or comments. I'm always trying to get them involved in kind of coming up with a solution, or at least make them feel like they're involved. And at the end of every interview, which I think that you do too as well, is that you just invite them to reach back out if there's anything that we can do to expedite allowance and emphasize the fact that we want to expedite allowance.
Yeah. And the way I think about it is, and we can talk about some other strategies for that, but it's easier for an examiner to call you and get on the same page than it is drafting a whole new office action, the prior certification, all that. And you want to kind of figure out a way how you can make the examiner's job easier. And I think that's a bridge to do that. And I was that, some of the other things, obviously, that's for interviews, but, some things actually I learned from you is, in general, for maybe one-on-one or in general, when you've prepared that response, when you amend the claims, what's your general approach for that to kind of get to a good place with both, getting the best possible result for the client in terms of claim, what you cover, and getting to allowance?
For me, the traditional approach is to basically make minor changes to the application or add on certain limitations to overcome the current rejection. my approach is different in the sense that, regardless of what the original claims currently say, my approach is to get us to an allowance that I think that would get the client what the client wants, and at the same time is still broad enough to cover other things.
Yeah.
But one of the things that I will often do is if I think that a certain limitation's there, it's not really helpful, it doesn't provide a ton of context, rather than just leaving it there, I'll just take it out, right? And so it seems oftentimes when I'm amending or making amendments to like a set of original claims, it seems like I'm taking out a lot of things, making significant changes. But really what I'm trying to do is I'm trying to make the claims both broad, concise, and at the same time make sense to the reader.
Yeah, and that's a huge, huge part of what kind of we both do is that sometimes you see these a lot of claims and they're like 2 pages long.
Yeah, 2 pages long. Yeah.
And then you look through prosecution history and they kept just adding and adding and adding features.
Right.
And one of those features that they added maybe 3 times ago comes and harms them, like in prosecution history or whatever, when you're talking about it. But in reality, what's the original claim? You don't have to accept that, right? If it wasn't drafted well or it wasn't drafted, you don't have to accept it. You could put it in the best light to kind of work with the examiner. And also, like, if the examiner, cites a reference that says receive information instead of receive a message.
Right.
And your whole prosecution strategy is on, it doesn't say receive a message. And it's like, all right, if there's even if there's a difference in that, it's like, you're not getting anywhere because the examiner is going to easily find a prior art that shows a receive a message. When you're preparing their response, you're really trying to figure out the same thing you're trying to figure out when you would draft an original claim is like, what are the best patent rights that we deserve in light of the prior art that's been found and that we know about and that's reasonable? Right. Because you also don't want to get a claim allowed that it's like clearly invalid based on the prior art that's being cited. So it's like you actually, we're on the same side as the examiner. We want to try to find out what is fair. And part of it is like taking out features, like you said, is that you don't need. Part of that is what you going back to before is that independent claim 1 is narrower. Your other independent claims, which are broader, as you amend independent claim 1 and the other independent claims, those still remain very broad. Yeah. I've seen like a lot of times we've both on the call with the client is like shocked about
how broad we got it.
Yeah, how reasonable of a scope we got. Yeah. We really get a claim that really focuses on the crux of the invention without having to put all this fluff to kind of make the examiner feel better about the claim being long. Right. Another strategy that I look from you, I guess, I've come to really appreciate is that you do this thing where you focus on one feature of a claim, maybe one step of a claim, and you try to really put as much meat in it as possible. Yeah. And can you talk about why do you do that, and like what's your thinking about that?
Because I think what I've seen in the past is that people just add a bunch of ancillary features and then argue that it's the combination of all those features that make it inventive, right? Yeah. What I like to do different is that I like to focus on what I think is the crux of the invention and then put in claims that are related to that support that.
And I think from a practical standpoint, examiners, when they're, 1 of 3 rejection, if you have different like steps, they apply these steps for these steps and these steps. What you try to do is like, through those amendments, is explain like, why was this really new? Right. And it's really the relationships between what's going on within that claim feature that really make it patentable. And then I think you told me it's like an examiner's not going to apply 3 references for one step of the claim. Yeah.
Exactly. Yeah.
And that works because you still get a very broad claim, and someone like, oh no, why are you taking out those features? But it's like no. When the examiner has to actually reject that, it's going to be very hard to reject that one feature. Right.
With 4 references or 3 references.
Yeah. And one of the things is obviously appreciates because kind of takes me to the next conversation. But if you don't do what we do during the prosecution of an application, you might end up having to file a continuation application where you're trying to kind of accomplish goals. And sometimes you see these families where, takes them like, I don't know, that's example, like 4 or 5 cons where they finally get to the scope that they deserved, which is great. But then that con is going to have to pay for all these other cons for the maintenance fees, and not to talk about like the prosecution costs and all that. So that's kind of a huge advantage of that.
Right. We pretty much get everything that they wanted in the first go.
Yeah. And I think then a con is really an opportunity to kind of really find other coverage and that's valuable in its own way, and kind of.
I think so. Yeah, agree.
So we can't end this conversation without talking about what everybody's talking about, which is AI, of course.
Yeah.
From all different angles. Obviously, me and you, we deal with a lot of AI inventions.
Yep.
So it's funny in some ways because I guess we should have seen the wave coming, right?
Should have seen it coming.
But it seemed like that was kind of something that engineers came up with or whatever. But then ChatGPT hit and it's kind of impacting us all. So we're kind of thinking about it. I know you kind of do that in your own practice. You kind of even before this wave, you've always come up with which is that's something else. Comes come up with little scripts and little macros to kind of make us more efficient. But now everybody's doing that. Everyone's thinking about it. So, or they're thinking about it. I guess maybe in this moment in time, what are you thinking about AI in practice? Where do you think this is going? Are you thinking we'll all be out of jobs? One thing I guess about from our conversation that stood out to me is how much people to people is involved, with the inventors,
right?
With examiners. But what are you thinking about the role of AI in our practice?
I think it's going to make us be able to draft better quality applications for sure. It's going to make that process much more efficient. I think that it will replace a lot of the crappy applications out there. But I think what it will do is that it will certainly make it the applications that we prepare for certain people much better, right? I don't think that. I think the way that the technology is going, we're kind of not really necessarily hitting a plateau, but in order to get the improvements that we're getting right now, it's costing a lot more, right? And so I think that we might have a little bit more time than we think, and we might have our jobs for a few more years, and so that might be enough for me.
I guess what are you seeing about the use of AI? Obviously, it was when it came out, people had different theories about what you should be using AI for or not when you're drafting applications, claims or background, or what are you seeing the use of AI that you think is working in terms of both on the drafting and the prosecution side that you think are compelling use cases?
Right now, whether it's for claims, spec, even drawings, I think it's very good at preparing a rough sketch draft, right? Something that will give you ideas, allow you to then take either pieces of that or come up with new prompts to have it generate, different things. I think it allows us to be a lot more creative because in the past you had to come up with all those things yourself, right?
Yeah.
And now you've got somebody to kind of cooperate with, right? To work with, to collaborate with, to generate, a lot of different ideas.
Yeah. Usually prosecution budgets don't allow.
Exactly. Exactly.
And it's funny, me and you do that a lot. We love to talk about a specific case and kind of figure out the best way forward. But now you can do it on every case, like you say.
Right, every case. Right. Yeah. I don't have to call you every single time when we talk about something. I feel bad about it.
Yeah. Yes, no, that's actually very interesting. I never thought about it as a way to collaborate, but I did think it's kind of a good tool in terms of filling in holes or blind sides that you might not have had, which is, I think, the more compelling reason is not just being more efficient at it, but is like you said, making a better, more robust application, which will be expectation. I think it is going to be replaced with. I'm less optimistic about seeing less crappy applications. I think you'll see other crappy applications crappy in their own way because I think you'll see that there's a lot of fluff that's kind of makes these a lot of
I just meant that AI will replace the people that write the code.
Oh, I see. So I see.
The crappy stuff will still be there.
Yeah. But I see. Yeah, because it's funny because I remember when it all came out, there was all these kind of. I'm like, theoretically, and actually on my own firm, we had these kind of debates or conversations. That theoretically, you don't need a patent attorney. You didn't need it before AI. You just could say, inventor, just prepare something, we'll file it. Let's still file the application if that's what you're going after. And that's going to cost you zero compared to a patent attorney. But if you're trying to kind of figure out, how to really capture an invention in a valuable way, you need to kind of deploy those tools effectively. And I like it. It's like a collaborator that you have there that works. Any, I guess, maybe compelling, I guess, for drafting, prosecution, anything else, compelling uses of AI that you find. I know, we maybe for like anything that helps, like in-house, kind of like invention disclosure is an issue. Anything that kind of stands out to you where you think like, hey, AI is something that people in our space should be thinking about as kind of using.
I think that anything that reduces the friction of the process is going to be good, right? If we don't have to have a bunch of back and forths, where you're sending emails back and forth, asking an inventor to review, getting invention disclosures from the inventors, like things like that reduce the friction or the things that people have to respond to.
Yeah,
I think that's going to be the most useful.
Yeah, it's like some of that stuff is like just automating things, and that's I think there's a lot of work to do, but I think that's the stuff that's excited me and you for a long time.
Yeah,
pressing a button.
Yeah,
if you could just press a button.
Oh my gosh, schedule an exam and interview. File the application, exactly, right?
And actually, I don't know if you saw, but the automated interview form is now behind Patent Center now.
I was behind Patent Center.
Yeah. So they just introduced it on March 9th. So I was like, the tools we built kind of make it more difficult, but those things that kind of reduce the friction and make it easier for everybody. I think that is an exciting aspect. Anything else, I guess, that kind of stands out to you as you think? I know you've done other stuff besides, patent drafting, prosecution. You've done some transaction works. You've been involved in some litigation. Anything else that kind of stands out to you about stuff that you're thinking about just in general these days about patents? And,
one of the things I'm working on is communication.
Yeah.
I think that in of itself is one way in which we can prevent ourselves from being completely replaced by AI. Human interaction is still a huge part of our job. It's a huge part of a lot of jobs. And so I think that getting better at communication, right? Taking a master course in communication is something that all of us should be doing.
Yeah. And no, I think that's great advice. I had a startup client who's unsurprisingly starting a business in the AI space recently, and very sophisticated person, on all kinds of issues. I would defer to him. But I saw when he came to questions about patent protection, they didn't just put in ChatGPT. They wanted my answer for every little aspect. And I almost wanted to stop to kind of compare my notes to what ChatGPT says. But I think it made me think of something like, this person I think this person could even figure out these answers on their own. But they saw value in coming to me and getting my thoughts and my expertise based on what I've done and what works, figuring that out. And, and I don't know how well I did with the communication part, but I did have to rely on that to convey to him, to at least kind of make sure that he still saw me as a resource for that. And obviously to add a value in a way that's kind of meaningful, right?
Yeah.
You don't want to, it's funny. I feel like these days people get excited about stuff that AI can do that Google can do, right?
Right.
Like you could Google, I have these symptoms or whatever. I have these symptoms for what it is.
Right.
And then the question becomes do you trust the first Google search results, or do you trust what AI, maybe the AI gives you a more confident answer, but I think at the end of the day, before you decide to schedule, maybe
I'm gonna go to a doctor.
Yeah, you probably want to go to the doctor, but at the same time, it's obviously valuable to get that first
Right.
input, or maybe put you at ease.
Right.
And so I think it's kind of a guardrails of
Yep.
of kind of putting that in. So I think that's a good moment to end on, to good on good advice there about kind of things we can improve communicating with examiners, with inventors, with clients, and with each other. So
Yep.
but we've been trying to do on Clause 8, so hopefully keep doing it with the age of AI. So. And thank you so much for doing this.
Thank you. Thank you for having me.